Did you know that there are some attorneys in New York who will yell and scream at a witness during pretrial testimony? Come join me as I share with you why I personally will never scream and yell at a witness during the course of a deposition, which is pretrial testimony. Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. There are some attorneys who believe that by yelling and screaming, they will intimidate the witness into getting the answers that they want. There are some attorneys who believe that they are superior to the witnesses that they are questioning, and by yelling and screaming, it shows their superiority. Well, guess what? I think personally that's a terrible strategy. There are some instances where I will have to yell and get into an argument with the defense attorney, but that is separate and distinct. Here, I will never, ever intentionally get into an argument with the witness. You want to know why? Because I don't need to. When I'm questioning a witness, I want to get information. I have a clear agenda, and I'm going to be asking questions in a very pleasant manner. Now, the witness knows that my being pleasant doesn't necessarily mean I'm being overly nice and I'm going to give them a pass and let them ride. That's not the case. Instead, there's a clear difference between being angry and screaming and yelling and asking the key questions that I need to in order to establish our case. So, for example, in a medical malpractice case where I'm questioning the doctor who you believe did something wrong, I'm going to establish from the doctor's own words what the standard of care was. And doctor, would you agree that if you did A, B, and C, that would be considered a departure, a violation from the basic standards of good medical care? Yes. Tell us why. And now I'm going to have the doctor explain, and I'm going to do it as politely as possible. And there are key reasons for that. Number one is a psychological reason. I don't want the doctor to go ahead and now we're fighting, verbally sparring. Why is that? Because I'm trying to get information from the doctor, from the witness that I'm questioning. And if I'm going and screaming and yelling, what do you think happens? Now they back off. Now they become defensive. Now they don't want to give you information. But on the other hand, if I'm being pleasant, if I'm being polite, if I'm being respectful, guess what? Now they recognize that I'm doing my job and I have to get those questions out, and they likewise have to answer those questions. And the whole dynamic changes totally when you take that respectful tone. I don't agree with what these people say, and I don't have to agree. But at the same time, I can be polite and I can be respectful. Yet there are still some attorneys out there who believe that by screaming and yelling and being intimidating is the right way to question a witness. For me personally, just doesn't work. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on during the litigation process in a case involving medical malpractice or an accident matter or even a wrongful death matter. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.